Yes.
Okay, now that we're recording, so I wanted to just sort of touch base on where we are and where we're going. Sandy and I think that we're on section 104, and that's where we decided to start this week. Is that work with everybody else? Is that consistent with everybody else's recollection? Okay, so we'll start on 104, and then we have 3 more sessions planned. So 2 sessions in April, or where April and May.
Yeah.
And we have 10 and a half more sections to go. So my thought is that we get through as far as we can today. And I'm hoping that we can get at least through halfway through section 2 today. But Sandy's thought is that we may need to schedule additional meetings and then start giving sections to legislative council starting in May, depending on how far we are. So we may not be able to give Sean everything all at once, but as long as we keep plugging away at this, we should be able to get him, I would think we should be able to get him half or 3/4 of the act in early May. That would be my hope, but let's see how quickly we can move through this. I don't want us to be rehashing old arguments when we're going through this. I mean, I think that the tendency to debate some of these things that we've debated before is really strong, but I just want to make sure that we've reflected all of the changes that, that we've incorporated. That said, we're going through it with an understanding now of having gone through the whole act once. So, there's some tension there, I think. So I just want to make sure that we're keeping our eye on getting this done and hopefully being able to move forward efficiently. I know we're looking at section 105 today, and that's going to be a big section. So, so with that in mind, I think we probably should schedule at least one more meeting for May, since I have folks on the call here. Let's see. So right now, Sandy, when is our May meeting?
So right now, what I have is we have April 14th, we have April 29th, and I actually think this is the third one. I actually don't think we have anything scheduled in May.
Okay, so why don't we try and get 2 set for May? And I know that those of you in academia are going to have some busy times in late April, early May. So, are there weeks that are better than others for folks?
Well, the ABA tax section is the second week of May. So that's kind of out for me.
So Valerie, for me, the first week is going to be the best. And then then the middle 2 are the worst because that's finals.
Okay, so what if we pick like the week of the 5th? And then a meeting the week of the 26th. So what does May 5th look like for people right now?
Good.
This is 9 a.m. to noon, so it shouldn't get in the way of any parties.
I'm sorry, Valerie, say the date again.
May 5th.
Cinco de Mayo.
Oh, there we go.
That's why you said the party. I didn't catch that. That was good.
And then the week of the 26th, we could do the 26th. Does that work for folks?
Mm-hmm.
Yep.
Oh, not for James. James, what day that week would be better for you?
Probably any other day. 25, 27, 24. I just have a board meeting on the 26th,
Sure.
but you don't have to schedule around me, of course.
Well, no, I mean, we want to have as much participation as possible.
Well,
What about,
and because school is over, Mondays and Wednesdays are fine for me.
okay.
I mean, it's just not good during the semester.
We're done on the 21st.
Okay, so what about the 25th? Does that work?
What about the
for people?
23rd? I can't do, the only day of that week I could do is the 23rd.
Okay, does the 23rd work for people?
Yeah.
Okay, let's do it.
Okay. I'll have Debbie send something out ASAP. Both those.
Typed into my calendar as OLCC meeting. Like that's exactly the same.
Are you, do you have a new, do you have a new job, Valerie?
No, I just have OLCC on the brain for some reason.
That's what I mean. Yeah, are you on the liquor commission?
Okay, so how do I get rid of that? Hold on. Okay, so great. So I think that will help. And we should be most of the way through this by the end of that. And we'll follow up with Sean to make sure that he's okay with the change in timing, but I think he should be. Especially if we're going to start giving him things to work through. Okay, great. So anything else before we get started? Great, let's get started. So we received an email this morning from Jeff saying that he's going to step down from this work group. So we're going to have to navigate our own way through section 1, but we did a pretty good, I thought we did a pretty good job last time, so we should be able to keep up the good momentum. Okay, so section 104. I don't have any changes in section 104.
You want, but does it want me, just real quick, does group want me to share the screen?
Yes, please.
Okay, I'll do that right now.
That worked really well last time.
Sorry, my computer's being a little finicky this morning, but here we go. Okay.
Great. Okay, so section 104. Yeah, I don't have any changes to section 104. Section 105.
And let me state really quick before we get to 105. My notes on this one were all over the place because I think we discussed this like 3 different times. So there's definitely some areas that I may have marked down wrong.
Yeah, let's just start at the beginning. So with section A on 105, I also had the change from act to chapter.
Okay.
And
Where is
then,
oh, there it is. I see it. Thank you.
yeah. And then on section C5, I have in my notes the duty of care here. Is that consistent with other people's recollection? Okay.
Is that marked correctly at this point? That the duty of care?
Yes, and I think that was because that was a policy decision that the legislature had made that we were
Okay.
trying to reflect in the revision. Okay, so and then, are we keeping manifestly in 6?
We talked about it a lot.
We talked about it last time, and I think the group consensus was to keep it.
Okay.
I'll flag that I have some concerns about the switch from the current Oregon language of unconscionable and unreasonable to manifestly unreasonable.
Yeah.
But at least at this point, my understanding was that we had agreed, at least we'll get to the definition of manifestly unreasonable later, but at the present moment, I think we had agreed to have this change made. So, or at least to maintain the word manifestly in there.
Right. Okay, good. And then 7, where in part, we were exonerate a person from liability for conduct involving, so I have this in my notes as well.
I have a point to raise on this one.
Yep.
One, under Oregon 63-160, one of the things that you cannot eliminate or limit liability for is unlawful distributions, which ROLCA, I think, allows you to do. I think that's something that we should maintain the Oregon policy on. So I think, here we've, through our red lines, added breach of the duty of loyalty. I think we ought to also add improper distribution here as well.
Does violation of law encompass that?
I don't think it inherently does.
I agree with Cody. I mean,
Under Oregon law, violation of law is defined separately, or at least it's listed separately as something that you can't. Yeah,
And I think I think in chapter 4, there's something about that. Definitely there's stuff about distribution, but we should make sure we define improper distribution if we're,
Yeah, can we reference?
yeah. We should reference section 406, and I think
Right,
whether it's on improper or unlawful, we should use the 406 language. Improper distribution under section 406.
yeah, can we use the words similar to what you see down in 9 specified in section 406?
that's a great.
Is there a subsection there?
with specified or as defined in? I mean, I don't know. I mean, specified in 9 seems to, well, maybe, I don't know. It doesn't matter to me really, but
Yeah, or you could, there's language in 8 that says under section.
oh yeah, I like that.
I think just using some kind of consistent language.
Yeah, I think
Like
under is
105.
good. Yeah, I like under because it's shorter.
Yeah,
I'm just seeing if there's a.
This is also the type of thing that LC will tweak anyway. So I think as long as our intent is here, I think it's fine.
That looks great. Okay, add a comma and we should be good to move on.
And capitalized section.
Capitalized section. Yep, I hear you.
Okay, great. Okay, anything else on 7? Okay, 8. I don't have any edits to 8 actually.
this was one that we had discussed in part as part of our discussion of section 410. This was one that we hadn't, I don't think we'd actually discussed it very much. But my thought here is to keep this consistent with current Oregon law. And current Oregon law doesn't let you do all the things that ROLCA lets you do. I would propose that we use the following language here as the entirety of the language for this section 8. Have it say, vary the duties and rights under section 410, except as otherwise provided in that section. What we had done with section 410 itself is we had followed mostly what Washington had done. And in that regard, they have language allowing you to impose some restrictions. But I think we just leave it as defined in section 410.
So Cody, I'm trying to keep up. If that's what the group wants, I'm happy to add it.
I feel like unreasonably restrict is a different standard than vary.
Well, it is. The word vary comes from ROLCA up there in 2, in 3 and 4. They talk about varying. And when you look at what we had, and maybe, it's a little bit sort of discombobulated to discuss this in section 410 as well, since we, right now we're only talking about the 105. But in 410, what we had agreed upon as the language, at least according to my notes, was we were going to say the limited liability company may impose reasonable restrictions on the use of records and information obtained under this section, including designating information confidential and imposing non-disclosure and safeguarding obligations on the recipient. In a dispute concerning the reasonableness of a restriction under the subsection, the company has the burden of proving reasonableness. That is what my notes say we had agreed to for what would section 410 would be saying.
Mm-hmm.
And so a lot of this language that's in ROLCA 8, at least the portions of it that we had decided to adopt as part of 410, is in here.
When you say in here, Cody, you mean is in 410?
Yeah, I mean, it's not we didn't, when we discussed 410, my memory and my notes indicate that we didn't agree to authorize all of the changes that ROLCA would authorize, all of which are they're all, right now, Oregon law does not allow you to put any limits on a member's right to
Cody,
information.
what's the ORS cite to existing Oregon law on that? Do you know?
It's, yeah, give me a second. I'll have to look up
I think it's
410.
ORS 63771 and 777 that address the right to inspect records.
Thank you.
Yeah.
So just in and of itself, this language under ROLCUS seems, if you unreasonably restrict, but then you say you can be reasonable, that seems kind of circular to me. And
That's why I had proposed just using the word vary here.
I like that.
Yeah, I think I like that too, but I think we should flag it for legislative council and drafting, just to say, you know, the reason why we're doing this is to make it more consistent with where we went with 410, but also the prior language. Does that sound reasonable?
Yeah, so I just want to make sure I'm noting this correctly. We want to take out the word.
Unreasonably restrict and change it to
Okay.
very.
Okay,
Very, yeah.
sorry, it's being slow.
I guess I would raise the question, what's wrong with unreasonably? I mean, it implies an objective standard.
Well, that's
If
true.
we say unreasonably vary.
Yeah, I think we need to have the reasonableness or unreasonableness modifier.
But isn't the point
Or
that the
qualify.
reasonableness modifier is in section 410? So what we're saying, if there's like, I don't know, it gets confusing if you say you can't unreasonably restrict the duties under section 410, and then 410 says you can reasonably do something.
Yeah, I agree with Kyle, and I didn't really object to unreasonably restrict. I just thought that if you say unreasonable and then you say, but you can be reasonable, it seems redundant. So it's really the combination of unreasonable and then, well, don't be unreasonable, but you can be reasonable. Well, yeah, of course, that implies that don't be unreasonable implies you can be reasonable.
No,
Hey,
I agree.
I guess I see 105 as really talking about what you can do inside the operating agreement, whereas 410 is the substantive rules. So I think they're looking to the four corners of the operating agreement and what you can put in there.
Yeah, I think I agree with Michael. I think 410 doesn't. I mean, I'm just scanning it. I was not there for the discussion of this, so excuse me if I'm missing something. But scanning it, I don't see anything in 410 that says the operating agreement may reasonably restrict the rights of a member to access information. It just lays out the rights of a member to access information, and there is reasonableness language in there, but it basically discusses affirmative rights of members to access information. What we're talking about in subsection 8 here is, can the operating agreement include language that limits the rights that are laid out in 410? And so I would keep the language as is based on just the structure of the act itself. But again, I'm not sure if there were other changes agreed to in 410 that would make this change here appropriate.
Well, we didn't adopt 410 as written.
Right.
We essentially, when we got to 410, we used, instead of using 410 as our model, we used RCW 2515-136 as our model, which was substantially different from 410. And then we did meld some portions of 410 onto the RCW language, as well as some language, I think, from current ORS. But so looking at what ROLCA 410 says it's not what we decided.
Fair enough. Thanks for that clarification.
Yeah, and I get what Michael's saying about the standard here. And I think that, well, first of all, I think it shouldn't be varying, it should be vary. Sandy?
Very, should be VAR.
Why?
Okay.
No ing.
I was just, I'm listening.
So I guess the question to the group is it important to insert unreasonably, and I get what you're saying too, Roberta, about that, but insert some sort of standard before vary, understanding that if you look down at 1314, they don't have any sort of threshold there, any sort of objective standard.
To me, it seems that if you put the word, regardless of whether you use, restrict or not, if you add the unreasonably, what it says is that you cannot unreasonably change the fact that the LLC may impose reasonable restrictions. And I mean, to me, it sort of, makes it circular.
Well, and as I think about this, and as we talk about it, one of the hallmarks of the changes they've made to the LLC Act over the years has been a focus on transparency, right? And so, I think if the unreasonably restrict language is, I think, veers away from transparency, whereas vary might veer more towards transparency. And for that reason, I'm in favor of leaving the language with the word vary, so that section 8 as we have it right now, and then pushing it to legislative council and just making sure that they're okay with it from a consistency perspective.
Yeah, and I mean, I think that it is a bit of a change. The substantive fact that an LLC could put these reasonable restrictions on the use of records and information is a change from current Oregon law, which is already giving LLCs sort of more authority to be less transparent, if you will, than they were previously.
Any more discussion on this section?
So Cody, just making sure, and Valerie, the way it reads right now is I should keep it for now pending LC looking at it.
Yeah, and please flag that in the comments. So we're in section 105C8 that says an operating agreement may not. So
yeah.
And the other thing, Sandy, is so what we were just talking about is, so you have the vary the duties and rights under section 410.
Yeah.
But then everything after that would be deleted and it would be replaced with the phrase except as otherwise provided in that section.
No, I think Sandy's talking about everything after the comma following 410, right, Cody?
That's what, yeah. So like the fullness of it would read, vary the duties and rights under section 410, except as otherwise provided in that section.
Yes.
Right.
Do we want to put a pin in 410 to look at this again,
Yes,
to
I
go
just-
back and look
I
at
just made a
105?
note. I just
Okay,
made a note after we go into 410.
great.
I agree, Roberta, that makes sense. Yeah, perfect, Sandy, thank you.
Yep.
Okay, section 9. I don't have anything in 9.
Oh, sorry. There we go.
I have that we added, because Oregon has the shell entity rule.
Right.
And so we need to add after 701A4, a reference to, I guess we need to say and 701A, 5 or whatever it ends up, wherever the shell rule gets codified.
Yeah, I agree.
Okay. I get the, let's see, reference to, and I've added that a bunch of times in the statute. I just put the definition in today when we were talking about 101. So it's in 661 or something.
The shell definition, you mean?
Yeah.
Yeah. Well, and
But they're gonna put it wherever they put it. We just need to make
Right.
sure.
Yeah.
Can I,
Council or judicial dissolution.
so can I raise a point here? What this section is talking about is to what degree the operating agreement can vary the rights of the members. And is dissolution of a shell entity a administrative proceeding or an enforcement proceeding that's not brought by the members?
No, you know, that's a good point. Maybe we don't need to have it.
Yeah, I
Because
don't think we
701A4 is talking about on application by a member.
Right, and what this provision is saying is members have that they have that right and it cannot be waived or modified. But of course, we can't waive or modify a governmental right to.
Yeah.
To-
Well, and the point you're making is codified in ROLCA section 15 below, which says that with certain limitations, you can't restrict the rights under this act of a person other than a member or manager, which would include the Secretary of State. So
I guess
I think you're right. I don't think we do need, I think we can just adopt 9 as is.
Okay, 10. I have no changes on 10. Or 11.
Same.
Is everyone, just real quick, I'm getting some requests to Zoom. Does it look better now?
Yes. I have my bifocal prescription.
I'm here to serve, whatever makes it easier for you.
It looks much better, Sandy. Thank you.
On 11, did we do anything with unreasonably there?
This is one we had not reached agreement on. You know, this is one that ties intimately with our discussion of Article 8 itself, which we still hadn't, you know, is also a sort of a football, if you will, a political one, I mean. The proposal that Kyle and Aurelia and I had come up with for this would be to have it simply say, restrict the right of a member to maintain an action under Article 8, except the operating agreement may require A, pre-suit mediation of such an action, B, arbitration of such an action, C, that such an action be litigated in a particular forum, and D, that the demand described in section 8021 contains specified information to be made by specified means. Current Oregon law doesn't allow any restriction at all. This would be an expansion of the company's, you know, the operating agreement's ability to control shareholder actions or, you know, member actions. The part that I just mentioned about that the operating agreement could require that the pre-litigation demand contain specified information and be made by specified means, that's in current Oregon law. But the stuff, but the other provisions are not in current Oregon law. I see Mosen asking about mandatory arbitration. Current Oregon LLC law doesn't say anything about that. Obviously, the FAA, you know, requires that you can't restrict arbitration to the degree that that's under, you know, federal law. That's not as a matter of state LLC law.
We're not talking about the Federal Aviation Agency, are we?
The Federal Arbitration Act.
So my husband, the former airline pilot, made a face just now.
Valerie, can I make a point?
Of course, Michael.
I just want to remind everyone, big picture, one of the significant elements, and we've talked about this, of ROLCA is the primacy of the operating agreement. It, in my opinion, is meant to give greater latitude to the parties to design their own operating agreement. And our carpet layers, they need to look to the default rules because they may not have a nice, clean written operating agreement. So that's point number one. 105 really is the backbone of that freedom of contract principle. And it says, notwithstanding that freedom of contract principle, here's the things you can't do in an operating agreement. So I guess I'm concerned that, we start really chopping up 105 here. And I hope everyone realizes that that's what we're doing, is we're really, I think, undercutting the premise of what ROLCA is about. So enough big picture point there. I just feel like we're chopping this up in ways that I think there could be unintended consequences. So enough said.
So Michael,
Michael?
is your recommendation then to not make changes to 11 and to leave it as is?
It says you can't unreasonably restrict the right of a member. Okay, well, that again, when you see a reasonable, unreasonably, we're implying an objective standard that the trier of fact can, in effect, determine if someone is just completely off base in their operating agreement. That can, in effect, I think the remedy would be that provision would be disregarded.
Michael, I share your, I come from a strong freedom of contract perspective here. But I kind of like Cody's modification here better, because unreasonably restrict leaves it up to a judge untrained in LLC law to make the decision about what's reasonable, whereas Cody's itemizes the things you can do, and all those are the reasonable kinds of things I would want to be able to do in an operating agreement. And so, at least with respect to this particular change, I think it's an improvement.
I would just like to flag that the litigator here is suggesting language that would decrease litigation potential for this, I think.
Well, and one thing that having a list is, which is very helpful, right? But sometimes courts look at lists and say, oh, these are the only things you can do.
It's prescriptive, right?
And so maybe we should have including but not limited to, if that's.
Well, no. That, I mean, the whole point of this is to have a specified list that is
Okay, so
not an including, but that is not an including. These are the changes. And I'll note that if you look at the comment, if you look at the comment to this subsection and on page 31, like these are the things they're talking about. That they're specifically having in mind. That would be, the ROLCA leaves it open for additional restrictions to be imposed beyond pre-suit mediation, forum selection, arbitration. This, for example, require universal demand in all derivative cases, even when demand would be futile, which is a change I think that in when we discussed section 8 or article 8 earlier, we didn't agree to. Or we agreed not as a group not to adopt that change, which is why it's not listed here.
So then that, I would then probably, if we want to make it an exclusive list, I would take out the unreasonably, because if you have.
That was part of the suggestion.
Okay, great.
Yes, that would, that was part of this. This clause would just read restrict without the word unreasonably. It would just say restrict the right of a member to maintain an action under Article 8, except, and then it would give certain specified exceptions to
Cody,
that.
do you have that language typed up that you could cut and paste that into the chat?
Yeah.
Cody, if you have it up, you also could add it directly into the document. You have ability to, if you have it up.
No, I don't.
Yeah, but while we're all together, it might be easier, better just to
I think put it in the chat and then
do that.
Andy, can
Okay.
you paste it into this section so we can look at it?
Chat can be weird and copy paste. Let me see if it lets me. There's been some Zoom settings in the past that haven't let me do that, but let me try.
So Cody, when you say ROLCA would give more ability to modify things than under current Oregon law, does current Oregon law actually say that you can or can't restrict a right to maintain an action, or is it implied and through case law? Is it already kind of a reasonableness standard?
No, there isn't. No, under the Oregon Act, it's like, here's the rights and here's the limitations. And then when the Oregon Act says oh, you can modify that, the phrase sort of except as stated in the operating agreement, or except as otherwise stated in the operating agreement, that's sprinkled throughout the LLC Act that we currently have. And that is the signal under our act that you can vary the law. Under ROLCA, the assumption is you can change anything unless it's listed in section 105. So the default presumption is different fundamentally between chapter 63 and ROLCA.
I guess I'm still struggling with that because I feel like we do all of these things already. We have venue clauses, we have arbitration clauses. And what you're doing, I think, is eliminating the gap filler stuff, the stuff that's not A, B, C, or D that we don't have itemized in front of us and who could think of all of it. That stuff would in theory be potentially permissible under 63, and this would make it not permissible.
Well, I think on form selection clause, mediation, arbitration, nobody challenges that. They've agreed to it as a contractual matter, and nobody challenges that. But additional frustrations, additional hurdles that the operating agreement can impose could include a variety of things. I can't even think of all the things they could be. But then in your typical action brought by a member against an LLC or against other members, you're going to always have this threshold thing. Oh, did this member have the ability to bring the claim? I mean, for example, Oregon law currently doesn't codify what exactly are the circumstances under which you can bring a derivative claim. ROLCA does do that. And, we haven't agreed as a group what those circumstances are exactly, or what exactly are the circumstances under which you can bring an individual claim. But now that we'll have codified when can you bring an individual claim, when can you bring a derivative claim, then ROLCA, if we adopt their section 11 here as is, they can say, for example, we're going to eliminate your right to bring an individual claim in certain circumstances that ROLCA would otherwise allow you to bring an individual claim. And that Oregon law currently allows you to bring an individual claim.
So I think I come out where Michael was on this. Then I think I personally would view whatever people agree to in a contract as what should govern. If they've got a contract, they've got a contract. I don't think these kinds of things are so unreasonable that they would be impermissible in all circumstances. I think if you could agree with a big private equity firm to some restriction, two sophisticated parties, I don't mind letting people live with that deal they've struck. That's different from what the default rules would be for the carpet layers. But I think anyway, I come out where Michael does on this one.
Yeah, what if a carpet layer, well, I mean, probably seems unlikely, but a carpet layer is entering into an agreement with a sophisticated party? Is that a reasonable possibility?
I think that's what I see in my practice is cases where there's an LLC where there's one sophisticated party and a lot of unsophisticated parties, and the sophisticated parties rams some very, very unfortunate terms down the throats of the unsophisticated parties. Not even rams them down. The unsophisticated parties aren't even paying attention at the time that they enter into the LLC. So some sort of guide rails for that type of situation seem to me entirely appropriate.
In my view, the really sophisticated parties, per Motion's comment in the chat, they all go to Delaware. That's where you can get rid of all the fiduciary duties, for example.
Yeah, and I think Oregon, our legislature, given the current regime that we have, as well as the courts that we have, and as well as I think just our culture being different from Delaware and not, having an economy driven by the most cutthroat corporate regime in the country. I think we take care of each other a bit more ethos than a pure, have at 'em, knives out culture. And I think that's something that we should preserve, is the ability to protect people.
I totally agree with that conceptually. Where you draw the line is, of course, the challenge. And my own view is the more of these things that pile up, the more likely the average bread and butter client that we have, the general advice is just going to be go to Delaware. There's too many nanny state things in Oregon. There's too many things you can't vary. let's just do it in Delaware or even, a different state.
But James,
Anyway.
what is our purpose in going through this exercise we've been going through, right? Is it to make Oregon LLCs more attractive?
I think
Or-
that is actually part of it, and that's part of the reason why we were organized to do this, is because it has been so long since we revisited our LLC Act that we are out of step with a lot of other nearby jurisdictions. Even setting aside the whole Delaware thing, whatever. I think that we made a decision early on to be consistent with ROLCA whenever possible. And I see what Michael's saying is that this is sort of backing that off. I would like us to take a straw poll, because I think we could probably talk about this for the rest of this morning's session, and see where we end up on either the language in ROLCA, which is that first black part of 11 that we've got on the screen now, or the proposed language, which is the language in red. Because I think, and then we can put a pin in this and come back and have, additional discussion when we get to 8, because I think that this is going to be informed by our discussion in 8. But I would like to see where people end up, where people are on this right now. So everybody who would be in favor of keeping the ROLCA language, and Sandy, can you please keep track of votes?
Could you, if you're able, could you just vote by raising your hand? I could just see it better that way.
Yeah, so everybody who is in favor of keeping the ROLCA language, understanding that, it is perhaps more carpet layer protective, more unsophisticated, member protective. Oh, what did you do, Sandy?
I'll be able to see everyone now.
Right, but we can't see the language.
Okay, that was just,
Yeah,
I
screen
understand.
sharing. People can raise their hand within the screen sharing.
Yeah, I just got to get back up.
Yeah, so everybody who wants to keep the ROLCA language, please raise your hand.
So Michael, James, oops, Dave. Well, so some people are raising their hand virtually, and then some people.
Can you raise your hand using the reaction button so that Sandy can see it?
That'd be great. So 1, 2, 3, and also hand instead of thumb raise, because I've learned recently the thumb raise goes away. 1, 2, 3, 4, 5. So I'm seeing 5.
Okay, so everybody in favor of the red language, raise your hand.
One, 2, 3, 4.
David, did you raise your hand? Are you raising your hand for this
I
one?
did not count David for the second one because I counted for the first one.
Yeah, I'm right. I'm Zoom stupid, so I probably didn't do it right.
David, which one do you want, red or black?
Black.
Okay, so lower your hand.
I don't know. How do I?
Okay, so it's right now it's 5-4.
Okay, so we could talk about this for the rest of the morning. I think where we tentatively end up is on keeping the black language. But Sandy, I'm going to make a note, and I'd like you to flag this for revisiting when we get to section 8, because I think that we can't really talk about this one in isolation.
I'm just going to keep this in, but not in a different color, so it's clear that we have made a
Or
decision.
highlighted or something.
Yeah, exactly.
So when we say keep the black language, do we still take out unreasonably
No,
or?
I think we need to leave in. We're going either with ROLCA or we're
Right. So that one should be in black.
I'll highlight that as well as that we've not made a decision on it.
Yeah, and I think that I absolutely understand where Cody's coming from, and I think that makes a lot of sense. But I also I understand where Michael's coming from. So I'm going to put a flag in 105C11 to revisit at section 8. Okay, moving on. I had 12 completely stricken.
Yep.
Correct.
And then I don't have changes to 13, 14, or 15.
Correct.
Okay. Section D. We'll wait till, yeah, I don't have anything in 1. I actually don't have any changes until we get to D3D.
Um,
Oh yeah,
I
here we go.
agree on D1 and D2 all being as is.
Okay.
D3, I think it may be well, at least D3A, I don't think we had made any decision on yet. And on D3A, it makes substantial changes to Oregon law that I think
Andy, what did you
we
say?
need to stick with the Oregon law on. So Oregon law does not allow you to eliminate the duty of loyalty,
Right.
period. And what it does allow you to do, though, it is that, or it specifies what you can do here. And in particular, if you look at Rolka's reference to 409B and I, those are the things that it allows you to alter, eliminate. And then 409B I is just for a manager managed LLC, whereas B is for a member managed LLC. And the differences, let me bring up 409 here, is a few different things that Oregon law allows you to do, and Rolka also allows you to do, but then there's a couple things Rolka allows you to do that Oregon does not. And in particular, if you look at 409B, the first thing it says, which is your first fiduciary duty of loyalty, is to account to the company and hold as trustee for it any property, profit, or benefit derived by the member, A, in the conduct or winding up of the company's activities and affairs, B, from a use by the member of the company's property, or C, from the appropriation of a company opportunity. So that's 409B1. Under ORS 63 what is it, 155, I think it is, and 63 160. What you can do in Oregon is you can alter the duty as to appropriation of a company opportunity, but Oregon law does not allow you to alter or eliminate the fiduciary duty as to not deriving a profit from the conduct or winding up of the activities or affairs of the company, or from using the company's property. So to me, that reference to 409B that's in Rolka 105 C or D3A, I would not just have it reference 409B, but I would rather have it reference 409B1C so that it matches what Oregon allows you to do. The other part of 409 that matches Oregon law is 409B3, which imposes a fiduciary duty to refrain from competing with the company in the conduct of the company's activities and affairs before the dissolution of the company. And that is something that 63 155 allows you to do as well. So I would reference that specific section in Rolka 105 3 D3A. But by contrast, I would not be referencing 409B2, which is the fiduciary duty to refrain from dealing with the company in the conduct or winding up of company's activities and affairs as or on behalf of a person having an interest adverse to the company. That's something Oregon law does not allow you. That fiduciary duty, which Oregon law also has, you cannot alter or eliminate. And so I don't think we should make the change to allow people to do that either.
I think those are good suggestions.
So my suggestion would be to have this 3A say, alter the aspects of the duty of loyalty stated in section 409B1C and B3 and I, insofar as it relates to those two parts of 409B. Something
Cody,
along those lines.
I want to leave that or eliminate language though.
Hey,
Cody, doesn't Oregon law allow you to modify these things if it's not unconscionable?
Oregon law only allows you to modify the two parts that I mentioned if not unconscionable.
How
It's-
is 63.155 10 little a big A? It says that you can identify specific types or categories of activities that do not violate the duty of loyalty if not unconscionable. Doesn't that mean any kinds?
But that is different because that is already, give me a second. That's already, I think, called out for in D3.
So I'm gonna have to hop off, so I'm gonna throw in a few things. Why do we have section 25 in there? What is that about? You see that?
no,
Okay, what Sandy has up there, it says alter or eliminate the aspects of duty and loyalty stated in section 25.
oh,
Like, what is that? And then the second thing, Valerie,
Oh, it's a page number. It's somehow a page number.
oh, okay,
We're on
okay.
page 25.
got it.
So
That's going right now.
why do you want to keep eliminate? Doesn't alter include eliminate, or is it just because we want to keep the language generally of
I
ROLCA?
just want to keep the language generally consistent,
Okay.
and I think that there's a qualitative difference between the two.
Okay. Sorry to have to hop off. Good to see you all.
Nice to see you.
Bye.
Bye.
And I'm also on the substance of it. I'm okay with an operating agreement addressing what happens when someone, I mean, it's basically an interested transaction on page 108 of ROLCA sub 2. I very frequently, for example, will have an entity where one of the members is a lessor. Maybe they own the building where the company operates. Are we saying we can't have those kinds of transactions, or we can't govern for them in the operating agreement and say it's okay that we're paying rent?
Sorry, say that again. And this is as to
page-
409B2.
Yes.
Is that what you were just referencing?
409B2 seems to me to be focused on interested transactions.
Uh-huh.
And I think by rephrasing the way you are, you're proposing that the operating agreement couldn't govern interested transactions, or couldn't allow the operating agreement to govern them. Am I hearing you right?
Yeah, that you wouldn't be able to authorize people yes, you couldn't authorize them to engage in the B2 actions or the B1 A and B actions.
I think we need that. People have interested transactions with their LLCs all the time. You might be CEO and draw a salary that might have an employment agreement attached to it. You might lease property or license IP. There's tons of transactions that are quote unquote interested that are still in everyone's best interest to have happen. And I like for the operating agreement to be able to govern it, because I can say it's okay that Jane is getting a salary of X, and it's okay that Joe is getting lease payments of Y. I don't want to have somebody argue later that they're inappropriate.
Also, I think, James, you were making this point, which is, I think existing Oregon law is pretty close to this, to the ROLCA language. So I'm not quite following the changes that are being proposed here. I mean, there's some minor changes in the verbiage, but in terms of the substance of what ORS 63-155 allows, it articulates a fiduciary duty of loyalty that's very similar to what's in the ROLCA and in subsection 2, and then in subsection, I believe it's, I had it pulled up. In that same subsection, it does allow for you to alter these things in a manner that's not unconscionable, which I, by the way, I take that to mean the same thing as manifestly unreasonable.
Same here. Although that sounds like a great law review article.
No, thanks.
I would agree with both of the preceding comments. It almost seems like we're we're trying to create tighter restrictions than under current Oregon law.
Well, how do you deal with, for example, the language of 155-10A that says you may not eliminate completely the duty of loyalty under, the subsection 2 of this section, but you may identify certain things that don't violate the duty if it's not unconscionable.
Well,
then I
that's what
compare that
this,
to Rolka and it says, if not manifestly unreasonable, which is their version of unconscionable, you may eliminate the duty of loyalty.
I think what they're saying is you have to be reasonable in the ways you go about altering or eliminating. And I don't think they mean wholesale eliminate altogether. I think they mean eliminate for certain categories of activities.
Right, but I mean, when they're doing it, I think the Rolka language itself allows you to completely eliminate the entirety of the duty of loyalty. And you can get away with that unless a court says that that would be manifestly unreasonable.
And that unless is the key. I don't think any court is going to say it's not manifestly unreasonable.
Right, but Oregon law doesn't allow you to completely eliminate it, period. Like regardless of what a court
As
will
to
think.
certain categories of activities, it does. That's what 155-10AA says. You can eliminate completely the duty of loyalty if you do it in the following way, if you do it in a way that's not unconscionable. And I don't think they mean completely eliminate. I think if you had one sentence that says there is no fiduciary duty of loyalty, I don't think that gets upheld. I think that's unconscionable. But if you say, here's a particular slice of transaction, if you have a contract with member X and it's, substantially fair or on arm's length terms, or you put in some kind of standard, I think that's when your operating agreement serves the purpose you're trying to achieve.
So is it your understanding that Rolka makes no change to Oregon law other than replacing the word unconscionable with manifestly unreasonable when it comes to the duty of loyalty?
I mean, not having studied it in extreme depth other than on this meeting right now, yeah, I mean, I think that's how I read it, that it's really just changing the unconscionable for manifestly unreasonable. But otherwise, it's allowing you to put in your operating agreement what kinds of things you want to allow. And it's got a line that litigators can fight over if you go too far. So I think it's good the way Rolka's got it currently.
So
yeah, Cody, to answer your question, I think it essentially gets you to the exact same place as what Oregon statute currently provides.
Mosin,
What-
it seems that's without the added subsections. You're saying?
The existing language of Rolka
Yeah,
is
so without the
essentially, yes, with respect to the duty of loyalty, it gets you pretty much the same place. And I would hate to revise this because this is core language now that we're talking about here, and I would hate to revise this in a non-uniform way because it will put us out of step with other local jurisdictions.
So can you give me an example of a case that you can think of? I mean, I'll tell you, I litigate these cases all the time, right? I don't just draft the contracts and often it's not the carpet layer against the venture capital. It's often the somewhat sophisticated regional business, some company that's making 7 to 8 figures in revenue, et cetera. These are people who are successful business people. And then they get into a fight with each other and they realize, oh crap, I signed away my rights. And, now, I'm the silent partner and then the operating partner has gone and done all this terrible stuff and I can't sue them now. Or now I'm having a fight about whether I can sue them and they've taken advantage of me. And, oh, I just signed the form operating agreement that either I got off the internet or that, my lawyer had me sign, but I never thought that my partner would cheat me. And if I had thought of that, I wouldn't have agreed to these terms, et cetera. And so I'm just curious, what about those people and what do we do for them? And then B, I'm curious, are there examples that you can think of restrictions on the duty of loyalty that Rolka would authorize that current Oregon law does not?
Well, that's the question I was going to ask to you, Cody. What is there a provision that you can think of that is currently prohibited under the current Oregon LLC statute that you fear Rolka would permit And the example I've heard so far is a outright waiver of the fiduciary duty of loyalty. And I agree with you that this language of ROLCA does not prohibit an outright waiver of the fiduciary duty of loyalty. It only says that an outright waiver is unenforceable if it's manifestly unreasonable. And the point that I think, at least I'm making, and maybe James as well, is that in a circumstance where someone has been cheated, there's been deceit, fraud, or any other kind of untoward business practice, right? That's the situation where the court would say, well, enforcement of this provision is manifestly unreasonable.
Yes, yeah. So here's a question: why do we have 63-155-11? Why we're certain, because our definition of what the fiduciary duty is, under current Oregon law, it's essentially identical to ROLCA. Then they say, oh, here are examples of the, here's what you can do for specific types or categories of activities that you can say don't violate the duty of loyalty. And they call out specific ones. And I know it says including but not limited to, but why do they call out, and maybe Michael knows this from the historic perspective, why do they call out, one half of the fiduciary duty of loyalty and not the other? If their thought or intention was that you could, that they were going full ROLCA already back when they were drafting this section 11, why didn't they do that? Why did they call out those sections and not others?
I don't remember specifically here. I think 11 was added to basically as a belt and suspenders provision that clarified what was already in 10 previously. So, and again, include but not limited to, you see that language. It's meant to be illustrative in a way that clarified pre-existing law.
And so in clarifying it, I'm just curious, why didn't they add interested transactions or profiting from the property of the company if their thought was those are just as waivable as the other duties of loyalty?
My own guess is if you were a corporate lawyer in 1993, and I was in junior high school, so I was not. But if you were a corporate lawyer in 1993 and you were trying to figure out what is this new creature, this LLC, these are the kinds of things you were probably concerned about being imported from the corporate context without someone expressly saying you can engage in a transaction, you can compete with the business. I think people would have been worried that there were going to be some implied obligations under the Corporate Act that bled over. That's just a guess, but.
Well, and Cody, to your specific point about an interested transaction, why it's not specifically called out in subsection 11. I agree with Michael's point that subsection 11 is just illustrative, but I see where your question is coming from. To me, it is already called out in subsection 10, which says, I'm talking about ORS 155, right? It says that you can't eliminate the duty of loyalty, but you may identify specific categories of activities, for example, self-interested transactions that do not violate the duty of loyalty if not unconscionable. So if the operating agreement sets out a procedure by which interested transactions can be approved, right, and so long as that procedure is not unconscionable, that would be enforceable under existing Oregon law. Or under subsection 10A(b), specify a number or percentage of members, whether interested is whatever, to approve the transaction after a full disclosure, right? That's saying you can already cleanse the taint of a conflict of interest in the operating agreement without violating the fiduciary duty of loyalty. A court can't come back through the back door and impose a fiduciary obligation when the operating agreement already specifies how to deal with conflict of interest scenarios.
So, I was just, but it seems to me that this section 11 was fully negotiated and hashed out in the legislature, and not in 1993, but it was done in 1999. That language of 10A that you can identify specific types of categories, that was not added until 99, and then they had it for the equivalent of one legislative session, and immediately they went back in 2001 and added the list under 11. And, again, already knowing what the full scope of fiduciary duties is. And so I grant you that the language of 11 is in including but not limited to language, but it's also, maybe it would benefit us all to understand, maybe, I should have done more homework on this to understand what is the legislative history, what they were doing in 99 and 2001. But, they made a choice then to codify certain aspects of the fiduciary duty that can be the duty of loyalty that can be waived and not others. And, and I, even with the including but not limited to, and you would think that if this group was having this discussion right now and we were adding our section 11, I think, the point that Mose and James, Michael, et cetera, are making is you wouldn't have had section 11, or you would have just said, yeah, we can waive anything and everything unless it's unconscionable. That, without identifying, half of the fiduciary duties and not the other half.
Okay, so I think we've hit a point where we're arguing in circles again. So do we want to do a poll on keeping just the black language and adding the red language versus adding the red language? Okay, so those who are in favor of just keeping the black language, please raise your hand. Your virtual hand, which I can't find my virtual hand. Where's my virtual hand? Okay.
Look in reactions.
Yeah.
It actually counts for me. It's very, very nice. I'm seeing 6.
Okay. Lower your hands. Tara.
We're reset.
Okay. Those in favor of adding the red language.
I've seen 3.
Yeah. So for right now, I mean, we can always revisit this, but for right now, go ahead and delete the red language or yeah. But let's add another comment for legislative council to see if they have any concerns given the application of 63, 155 and 160.
63.
Yeah, because legislative council has all of the legislative history on these things. So if there's something that we're missing with respect to legislative history here, I want to know what that is. But I think our where we're moving on this is to get rid of the red language.
Yep, I'm doing it.
Can I just ask a clarifying question on this? Are we all in agreement that ROLCA does not allow for the wholesale elimination of the duty of loyalty?
I think that contrary to current Oregon law, the only protection you have from that is a court saying that doing that would be manifestly unreasonable, which the assumption is that a court would so hold. But Oregon law doesn't let you do that by statute. Like the statute says you cannot completely eliminate the duty of loyalty, period. So
I agree with you, Cody. Let me give you the following example. What if under current Oregon law, you have an LLC operating agreement that says, we're not eliminating the fiduciary duty of loyalty, but any transaction involving member X does not breach the fiduciary duty of loyalty. Is that a waiver? Or is that a specific category of transactions that does not violate the fiduciary duty? But my point is, I think you get to the same place under existing Oregon law. You can draft language that it's not couched in waiver, but is still essentially unconscionable because it's getting to a waiver. And I think the ROLCA doesn't do anything different in that regard.
Okay, I just find this language kind of interesting to say alter or eliminate aspects of the duty of loyalty, which is what this section gets at, versus section D further down where it just says alter or eliminate any other fiduciary duty, which to me seems more like a wholesale ability to ditch a fiduciary duty as opposed to an aspect of the duty of loyalty. And I wonder if we could just clarify in a comment the distinction that you kind of just laid out, Wilson, that we don't believe, or we believe it would be manifestly unreasonable to completely eliminate the duty of loyalty.
Well, I mean, I think the comment would be that this gets us to the same point that we believe current Oregon law is. Right?
Yeah, I would be interested I would have to read through the official commentary that the statutory drafters of ROLCA included to see if it already kind of covers that or not.
Okay.
Okay.
Yeah, and so Sandy, after the word history, could you please consider adding comment? Okay. 3B.
Valerie, I'm just, after in A, after 409B, original ROCA has the word and. So
Yeah,
Sandy, is your,
between B and
Um,
I.
That was inadvertently and I, correct? Is that right?
Yes.
yeah, and that should be ROCA black language.
Yeah.
Agreed.
Thank
There
you.
we go.
Michael.
Thank you.
Okay,
B. I have no edits on B.
Me either.
Okay. C.
So just real quick, I'd
Red.
earlier and I changed it based off the comment about C and D. So just letting you know where it stands right now.
Cool. I mean, so I have a question that what is B here? Other than essentially R 155.11. Why do they have B?
I take B to be kind of the inverse of A. A says you can take away, you can say that certain things, well,
I mean, isn't everything is an alteration that isn't an elimination? I mean, I note the commentary here says under B, an operating agreement might provide that an affiliate of a manager managed LLC will provide compensated services to the LLC at a price not exceeding market price, or that the manager may pursue opportunities that otherwise would be company opportunities. Such arrangements are commonplace and permissible. I mean, that's fine, sure, but why isn't that just an alteration of the duty? You know, to me, this when I looked at this is, and I meant to mention this when we were just discussing 11 and whether to modify 3A, but to me this is our 11 right here. So I just don't understand it. Or alternatively, if I mean, since they have their construct set up very similar to ours. Anyway, I don't mean to rehash the whole argument, but I think this is weird.
I take your point, Cody. I think it's weird too, because I can't articulate what extra it accomplishes, but
Okay.
I wouldn't change it just for purpose of
If
uniformity.
someone has a 3 a.m. brainstorm about this, definitely let the group know and we can revisit this. But for right now, how do we feel about C? Any edits to C as it's up on the screen?
And C, I'm going to make it black. The only reason it was red is because for some reason my initial notes I had it deleted.
Oh,
But I'm
no,
going to
we deleted D, right?
correct. That was just a mistake in my original notes.
Okay, so yeah, go ahead and make that black.
Yeah.
Why is it gray?
Because it's currently in a state of flux.
Okay.
Now it should be black. Oh, wait a minute. Sorry. I'll fix that.
Okay.
So I think that C stands, and as I'm understanding C, the only things that you can allow are gross negligence and reckless conduct. That's the only thing it's allowing you to waive. Is that a correct reading of this?
Yes, I think so.
That's my reading.
I don't know why it's gray. I will fix that.
I don't actually care. I just,
Okay.
it's not worth spending too much time over. Okay, so any other changes to C? And we got rid of D.
We got rid of D.
Okay, and then E, I
I
had,
don't know why it's gray, and it will go away when I accept all the comments.
okay, or when legislative council does. So,
Correct.
and then on E, I had that we had actually kept as a matter of law. Is that?
I'm sorry, what?
So in E, I had that we had crossed out, we had gotten rid of and then kept ultimately the matter of law language in E.
We're keeping it, yeah.
Yeah, that's what I have. So no deletion there.
I'm removing the strike through and putting it as black letter.
Okay, yes, perfect.
Got it.
And then is, did we keep?
What's up with the change on manifestly unreasonable to readily apparent?
I have a note that we discussed it, changing it to readily apparent, but I thought that we had left it at manifestly unreasonable.
My notes show that when we discussed it before, we left manifestly unreasonable. I'll throw out, I have, what we had discussed was just adopting E as is.
Yeah.
And I think that's what our group consensus was. I have some concerns that this new term, this new test of manifestly unreasonable as defined in E may authorize, more cutthroat terms than what current Oregon law allows with the unreasonable and unconscionable tests that we have. But I recognize what the group has decided so far as just adopt E as is.
Hey, Cody, just for the purpose of discussion, I agree with you. Manifestly unreasonable is a more permissive standard than unreasonable. I don't think it's more permissive than unconscionable. To me, those two are what is the word I'm looking for? Interchangeable. And indeed, this might be even a little bit more restricted because unconscionability in Oregon may require some element of procedural unconscionability that a manifestly unreasonable test would not.
Yes, and I grant you, it's not, I don't think there's any case law in Oregon that discusses whether any waiver of a fiduciary duty in loyalty or care was unreasonable or unconscionable. I don't think that those words have ever been applied, or elucidated by an Oregon court in this context. So it's hard to know what exactly the change being wrought is, in particular with regard to unconscionable, for the reason that you just stated. But certainly, the manifestly, which I think the manifestly mostly comes out in the language in E2, is it being readily apparent. I think that's essentially the definition of manifest here. That is more onerous on the injured party than current Oregon law. And anyway, I think I was promoting that we would adopt just a reasonable or unreasonable, it's plain unreasonable standard. But I think I lost that battle in our discussions.
And I do think though that we added this, the following factors shall be considered language that is in here. Because I have that in my notes as well.
Say that again.
So this language, the following factors shall be considered. I have that in my notes.
But it doesn't read right.
Doesn't?
Yeah, it
The
makes
following
sense. It's
factors shall be
ungrammatical.
considered, and then when shall make its determination.
Okay, so the court shall make it, the court shall, okay.
So
So we're getting rid of the following factors shall be considered as well, and just going back to the court.
Correct.
and keeping the word court.
Correct.
Yeah.
Got it.
Yeah, I mean, I thought our group decision was to just adopt it as is.
There was a lot of, that was one there was a ton of conversation on, and I'm glad we're clarifying.
I have a lot of cross outs and stats on here, so on my notes. All right. Oops. Okay, so we are done with.
Is E correct
Is there anything else that we need to talk about in E?
And don't worry about the gray, that'll go away, but the black letter looks correct to me.
Yeah, that's what I've got for E. Do we want to take a 10-minute break now and come back at 10:33? Yes, okay. So let's go ahead and pause the recording, Cindy. Great, thank you.
So I was looking over my notes during the course of this meeting. We discussed this back in July and August of 2020.
Yes.
Yes,
a
we
long-
did.
Okay, moving on to section 106. Which is on page 37 of the book.
There we go.
Okay. I did not have any edits to 106 or changes. Aurelia, you're muted. Oh, okay. I thought you were trying to say something.
I agree with that. I have a note that I can't recall what the point of it was. It says add comment that integration clauses are still valid.
Yeah, I have that. If you look, it's on the screen right now. I have that as part of our commentary.
Yeah, okay, but I don't know. I don't recall what what would we, I don't know whose idea that was or what we would say to effectuate that comment, but anyway.
I had notes. We talked about that for a long time for whatever reason, but it was a long time ago.
106A. Yes, I think that's fine though. I think that comment makes sense. Okay, 107. I have a bunch of circles and underlines, and we talked about this and that, but I don't actually have any changes to 107. Does anybody have 107 changes?
I have a flag here that we've marked under D for, you can see this is the notes I took a long time ago, that we were having just a conversation about potential conflict with the corporate statute. But that was just based off a conversation we'd had a long time ago.
Yeah, and I think that's fine. I think that's why I have so many underlines and circles here. But yeah, okay. 108. Additional
We
provisions.
did have a pretty good policy discussion about this, though we didn't end up modifying it.
Yeah, I agree.
Do you have, we were gonna add a couple comments. Do you have those?
Yeah,
Yeah,
I have a,
That's on the screen.
yeah. So, moderation, LLCs. Yes, I remember this discussion.
I had us wanting to add commentary that dropping the first sentence of 630742 was not a change in the law.
I'm sorry, 63.0472.
0742 was not a change in the law, and that likewise the same thing for 63, the entirety of 630743. And I don't know if we need it necessarily or not, but that's what my notes reflect. We had decided.
Yeah, I think that was the comment we discussed. 'Cause I have
Cool.
that as well. Yeah. Right, and I think that reflected our evolving understanding of the role of LLCs, was what I've got. All right. 110. Oh. Oh, 109. Sorry, I don't want to skip 109, but I didn't have any changes to 109.
So I have this orange section we had talked about, but we can, anyway.
Well, it was.
This is a DOJ request. We got this a long time ago.
Add that?
That's my notes was that they requested that that we look at adding language from 630741 to this act.
No, I think Cody's comment, I think what Cody noted about the comment on the prior section addresses that.
All right, then I'll get rid of it.
Yeah, I don't think that we need to add it to the actual statute. I think that it's just what they're concerned about is they want to make sure that we're not making wholesale changes to, broad authority.
Okay.
And I think instead of deleting it, go ahead and make a note that the group considered it and is addressed in the prior comment.
Got it.
Because we do appreciate DOJ's feedback on these things.
Sorry, it's slow reaction time sometimes. Got it. Okay.
Okay.
Well, I was just on that same one. I have a note that when we discussed 63.955, we had decided we would add a comment to section 109 saying that our deletion of the language of 63.955 is not a change in the law. And that 63.955 is the one that says an Oregon LLC may conduct its business in other parts of the country.
Right. But I think we restricted, we said that was going to be a comment, right?
Yes, that's just a comment.
So our deletion of 63.955 is not intended to change the
law, period.
Yeah.
Okay. And that's in the commentary section.
Right. And so I would, before that phrase, Sandy, I would add insert comment.
Got it.
Perfect.
Okay.
Yeah, with respect to 110, some of this is phase-in stuff that I think is just going to be mechanics that Legislative Council is going to have to figure out. And so I have a note here saying, a lot of this is going to be for Legislative Council to address.
I'm going to do one of those highlight things here.
Yeah, I think that's good. Because, for example, C1, I think we had deleted, but I just want to make sure. Yeah, it looks like you deleted it.
Valerie, is the phase-in question something that we need or should defer to Legislative Council on? It seems to me that that's a important practice change that is relevant for the lawyers to decide.
Well, I mean, I think that maybe we could insert a note talking about transition plans. That's because this is going to come in as chapter 63A.
Yeah.
Right. And so I think once we get sort of the things in place, then I think we should circle back with Legislative Council on, and maybe Sandy, what we could do is add a note saying instead of, where are you? Oh, I'll let you finish writing. Sorry, I'm talking at you while you're trying to do things.
I'm listening though.
Okay, so where you have for LC to address,
Yeah.
add in for LC to address phase in coordination with work group.
Yeah, maybe because it looks like I see you also have all this language a second time down under where it says consensus. You might only need this language the one time.
Yeah.
Yeah, I'm gonna get rid of it on the bottom. I'm actually gonna get, you know what? I'm actually going to get rid of it here because I don't want it to cloud the statute, and I'm gonna keep it on the bottom.
Okay. Yeah, wherever it makes the most sense.
Yeah.
No, I think what we're doing, Sandy, is deleting that whole red section. Where are you?
Yeah, I'm sorry. There was a previous copy paste. Live editing, it's a pitfall. I'm doing my best here.
Typing is bad enough in front of the audience, right? So.
And right now it's responding very slowly because there's a lot. I don't know So what I'm doing is,
So scroll up a little, please.
yeah,
Yes,
it's
scroll up and then delete that,
delete this whole thing.
the whole thing.
What? Got it. Now,
Okay, then,
now I have to go through and accept it. There it goes.
and then in the consensus,
Yeah.
just add a note saying that we want to make sure that phase-in is handled appropriately. So we're willing to work with legislative council on those rules.
Wait,
Okay, under C. No, go up a little bit.
I'm there.
Just mechanically, I don't think we need a 2 since we got rid of 1.
Yeah, I see that.
I mean, I'm sure. Well, no, I just think you get rid of the whole parenthetical, right?
Point, because there's now only one section.
Yeah.
Yep.
But I mean, that's the sort of thing Sean will fix. Okay, anything else on 110? Okay, 111. I don't have anything on 111. 112 has to do with naming.
This was a comment. I believe this is not meant to be Blackwater, the blue section here.
Yeah, so let's go ahead and move that into the.
Yeah, down below.
Mhm.
Well, what?
Oh, hold on.
Well, I mean, my understanding was that what we had decided to do here was not adopt 112A, but instead essentially do a copy and paste job from 630941.
That's my notes too.
Okay.
So I think we should just delete the language of A and then copy and, I mean, that's what we decided. I mean, we can rethink things, but this is what we had decided, I think.
Is it? Do you have the same thing that it's okay. So what we're getting rid of here, we're getting rid of this, and instead we're doing the copy paste. It's ORS 6394.1. That's correct.
Yeah, exactly. And then we will delete 112F and replace it with the language of 630942. At least that's what we had decided.
Okay.
Yeah, I think the point was the list of stuff you have to include and the list of stuff you can't include should not be a change in Oregon law. I don't know that the rest of the sentence phrasing matters, but I think we were trying to keep the naming terminology the same.
That makes sense.
That's my recollection as well.
I'm
I'm gonna need to get that language in the ORS, which I can do. I'm just gonna make a note. I'll fix this one after the meeting then.
Okay, and is that supposed to be RULLCA?
Well, that's going to be gone because I'm going to replace the whole thing with the language from 63094.
Okay.
Based off what Cody just said.
Yes. Could you change the acronym, please? Just because it's confusing me.
Where this right here.
Yeah.
Yeah. It's going to be gone, but yes, I will.
Thank you. I appreciate that.
No problem.
Okay. Okay, so we'll make the change to just substitute. That makes sense. I'm sitting here looking at 6394, and I think that's going to make it easier for Secretary of State too, which really should be one of our goals in this process.
We appreciate that.
With 1 and 2. Okay, good. Okay, anything else on 112?
Well, this is the language. I just got it, so I just wanted to. Well, I was on it.
Yeah.
And that looks good.
Yeah. And then 2 was going, okay, and then F had to do with the foreign entities though, right?
Yeah. So that I'm getting the foreign, so I'm getting the foreign entity definitions that are currently in 094.
So I would get rid of the adopt.
Yeah. Oh, sorry.
Okay.
And 090, the foreign definition 094 is 094. What section is that? Just to make sure I'm copying the right thing. It's section 2.
Well, it's not, it's in the foreign thing, right?
I'm just trying to find it.
It looks like it would be the language that's in 2.
In 2. So that's okay.
Yeah, that makes
it.
sense to me anyway.
Okay. Does that look right?
Will not contain the, yeah. Yeah, that's it.
Yeah.
Okay.
I would note that the language we struck in F talks about an LLC or a foreign LLC.
Right. So we should add in the foreign
Yeah.
limited liability company or foreign limited liability company name.
Good catch.
Okay.
Could you put, well, we're making these changes. Are we making our changes black or are we making them red?
I'm going to make that red.
Okay, so after a limited liability company in that first section.
Yep.
Add the word name before the word or. Sorry, I'm pointing to my screen and I'm just realizing.
I get it. Okay. Sorry, it's just reacting slowly, but I'm doing it. Okay.
Well, actually, Sandy, go back up to that section.
Yep.
Highlight everything from A, limited liability company, down to the period.
Yep.
And make that red.
Yeah. Good call.
Okay.
There it is.
So next, 113. I have no changes on 113. 114. I thought we added on section 114B after 906 the certificate requirement. Let's see. Is that correct? Is that in other people's notes? So the second sentence of 63-101.
I have to look at what we did on 906. I have on my notes, it's like crossed out. All the references to alternate name under 906 are crossed out. Am I the only one who has that?
I don't have that. Yeah, so what I have is if you look at 63-101, which I will insert in the chat, Sandy.
Okay.
I had that inserted at that.
Yeah, so my notes on 906 have us striking out the whole concept of the alternate name.
When we were looking at 906.
I mean, maybe I'm wrong, but
Let me look at 906 because
We did a fair amount of tinkering in 906. It may make sense to come back to this then when we
I
cover
was working on
906.
906 last week, Cody. I remember there being,
yeah, it looks like we did strike out. And that all has to do with the foreign limited liability company, right? Yeah.
so Valerie, just make sure I am putting in this language after the section 906 in B right now.
Well, that's what we had talked about when we talked about section 114.
Right.
But yeah, so go ahead and put that in red, and then we'll take out the language. So to register its name, and then I think Cody's right. We did, when we got to 906, we did get rid of all of the alternate name language stuff. So yeah, so I want to make that red.
I will. I have to do a step before that, which it doesn't like. Sorry, I'm talking to my computer.
That's okay. I talk to my computer all the time, usually in not very polite language. Okay. So yeah, I think Cody's right. I think in B, let's so to register its name and then cross out or an alternate name.
I'm just looking.
Adopted pursuant to section 906. So we're basically getting rid of, right? Does that sound right to everybody? So it would just read, to register its name, a foreign limited liability company must deliver to the Secretary of State for filing an application stating the company's name. Yeah, so strike the or an alternate name adopted pursuant to section 906.
correct. And strike the same language from 114A as well.
Yeah.
Oh, I have to. Come on.
Then
I see. It's right, and it's here too.
yeah.
And then I think we need to add the word and instead of the comma between the company's name and the jurisdiction.
Well, we need the comma, don't we? Oh no, stating the company's name and the jurisdiction.
Name.
Oh no, just add a comma after jurisdiction.
Okay.
Right. Yeah.
Well, no, you don't do it there because you need the jurisdiction of its formation.
Right, they need to be together.
So and add.
Just add the word and before the jurisdiction. But I think we need to delete the comma after jurisdiction.
Well,
Right.
yeah, now we do the jurisdiction. The company's name. Well, that's awkward though, right? Because then we have and the jurisdiction and the date of its formation.
Yeah, because they want the jurisdiction of its formation and they also want the date of its formation.
Right. So instead of adding the and there, put the jurisdiction of its formation, comma, and the date of its formation. Doesn't that read better?
I mean, I think we can just leave the ROCA language as it is. All we need to do is just because, I mean, they have 3 things in a list. We've cut off the 3rd thing.
No, I understand why you want to get rid of the comma and insert the word and. I just think that it reads weirdly to have the word and 3 words apart twice. Right? I mean, legislative council will fix it, but I just think it's awkward.
I do think in A, we need to also delete that language or an alternate name adopted pursuant to section 906.
Yeah, so Sandy, before we move up to A, can you delete the comma before that highlighted and?
I can. And the and so that's That's gone, though. It's gonna ask me to accept that.
Yeah.
Okay. And then we are keeping that in.
Yeah, I just think it reads weirdly, but that's fine. We'll let legislative council sort it out. So in A, if you go up to A. May register its name.
Oh, I gotta get rid of or an alternate name again.
Yeah, so everything from the comma after name to the comma before if.
Let's see it. I think so.
Okay. Okay, everybody okay with that? Jamie, does that look good to you, since this is gonna have the most impact on what you guys are doing?
It does.
Okay, good. Okay, 115. Yeah, and so you added in that language from 63, 111 there?
Yeah.
Okay. Yes, that looks good to me.
Yeah, I think we can just, so the way it says business in this state, I think if you, at the end of B there, like the roll call language, I think we can just add the words that is, and then continue with, in the red, located at a physical street address.
So I'd be getting rid of the registered office.
Yeah, get rid of this means the registered office must be, and replace it with that is.
Well, I don't know. I kind of like it the way it is right now. I mean,
Sure, well, we can leave it up to council. We got
yeah,
the,
they can fine tune that. I just want to make sure that we lift the language that we currently have after that whole trailer in Vernonia business. And then on section 3, C3, yeah, pursuant to section 118. That was the other edit I had there.
I'll put that in red.
Yeah.
I don't know what's blue.
and I don't know whether we're supposed to be doing it throughout, or whether we just want to tell legislative council, but in this section right here, it says the certificate of organization, and we had decided to stick with articles of organization. Like maybe we don't have to do that in our document. We can just leave that to council to.
Yeah, I think it makes more sense to just let Sean go through and do a global change on that. Okay.
And then I had a note that we had, oh, okay, good. No, that's great. No, that's good. You've got the comment I was going to say we should have. So that's good. I see it.
Okay, so 116. Yeah, we did make some changes here. So B need not government office. Oh, this is the, I have a completely unintelligible, unreadable note here. So is this consistent, this language consistent with other folks have?
It looks like my notes, don't ask me to explain them. One tweak, that part that's blue, I have of the company in that other jurisdiction. And I think it should be either in such jurisdiction or in that other jurisdiction.
Oh. Yeah, I agree. So go ahead and strike that, Sandy.
So I'm striking which part, just this?
That, no, the word that in red before what you had highlighted there.
Got it. That's the word that, understood.
Yeah, that.
I'm getting rid of
The
it.
other that. Yeah. No, seriously, go ahead and strike that, the gray stuff right now.
And we added that so it wouldn't actually be strike through. And then, so in such jurisdiction is how we want it to read.
I think that reads better, yeah.
Okay, so I'm gonna make it read that way.
Okay,
And I think you have a or that doesn't belong in there. You have just the line above, it says another jurisdiction for filing or of. I don't think the or should be there.
I probably just did a copy paste, but I'm happy to get rid of it.
yeah. 117. Resignation. I had a note on E. Yeah. So 211.
My note was that when we ended up discussing 211, we decided this was a non-issue.
Right.
Oh.
In other words, like when we had gone over section 117, we made this note. And then to revisit when we hit 211, when we revisited 211, we said, no need to change 117.
Go ahead and delete that note, Sandy.
Got it.
That's consistent with what I've got.
Okay.
118. The only thing I've got on 118. Oh. Yeah.
There we go.
The only thing I've got on 18, yeah, is a cross reference to 115B where it says that. So.
And I'll make that red.
Oh, man.
119. Oh, this was a whole discussion about last agent for service.
Yeah, this is a big one.
Oh, yeah.
Can you
Yeah.
scroll up a little bit? What I can't remember. You see how it says annual, biennial there in B? I don't have us. What is our rule? Are we annual or biennial?
Oh, good.
Yeah, so go ahead and strike biennial.
Okay.
Unless the Secretary of State would like to move us to a biennial. Putting that out there as an option.
And
I
we
think that'd
want
be a revenue loss, Valerie.
annuals. I'm going to remove the brackets, correct?
Yeah.
Okay.
I entertain myself some days. I have a note here about 63,731 C1 language. Did we include that in the 63,731?
Where?
Hold on. Service on foreign limited liability company. C. That numbering doesn't make any sense. 731C. Transacting business. Oh, for unregistered entities. So,
Yeah.
63,731 2C says that the Secretary of State is going to be the agent of the foreign limited liability company upon whom any process notice or demand may be served if they're doing business in the state without being registered. I just want to make sure that we're capturing that.
Yeah, just make sure. Where does this go, Valerie? Sorry.
I had it in B.
Okay.
What under B?
Oh no, it wasn't under B. It was under include language from 63,731. I have under D.
Under D. So right here.
Yeah. I don't know
Okay.
if that's the right place for it though. The written record.
I'll type some potential language here in the chat box, but it'll take me a moment. We had, there's just a lot of verbiage.
Thanks, Cody.
Oh, yeah, and that's what you have in the after C language here, Sandy, is the.
Yeah, that's what I had in my notes back when we talked about it, is what I had in red right here.
Yeah, and so that's where that's coming from is 63,731 2C. So you might just make a note that we want to keep the 63,731 2C language.
I'll be right when I do that. The word, sorry. But we actually want to put that in the, we actually want to put that in the statute, correct?
Yeah, but yeah, I don't care where it goes. I mean, I think although Cody's may have language he wants to suggest about that. We just need to make sure that there's a mechanism to do this. You know, I think you can just click on the red A.
It doesn't like when I do that. It's because it's like this two-step process. Once we accept the insert, now it's good.
Yeah, okay.
Okay.
Okay. Cody, did you want to do additional language in there, or are you okay with having legislative council just incorporate that?
Why don't we let legislative council come up with something and then I can compare what they do to what I
Sounds good.
think we had discussed. That sounds, put the turd in their pocket. If
Okay, 120. I have no changes to 120.
Hey, I have this note that again, this is from a long time ago about checking with LC about compliance with electronic transmission statutes.
That's fine. 121. I just had a comment insert here on 121 regarding 63,965.
Okay.
Which is reservation of power to appeal or amend.
I think that's what you would add it in the blue, Valerie.
Yeah. Well, I didn't add that, but that works.
Somebody did.
Somebody
yeah, I
said
know that
something.
sounds good.
Yeah. Okay, good. Well, look at that. We're done with Article 1. Yay! Okay, Article 2. Moving on. 201. And again, globally, we want the certificate organization to stay articles of organization.
Yep.
I'm sorry, go ahead. We can talk about 201, but then I want to go back to something that we had added to section or Article 1. We had talked about adding to Article 1, what would be section 122, the language of 63032.
60.
This is on the secretary. This is that newish legislation where the secretary can investigate companies and issue penalties.
Yes, but that's let's just add that as a comment before. So before section 201, Sandy.
Okay. Or 201, got it.
Wait, where are you? Yeah, okay. Just add a couple carriage returns and just say we want to include the language of 63032 here, or somewhere appropriate.
From 63202, is that what you said?
No, 032.
032.
Yeah, add it as a new section in Article 1.
Okay.
I would offset that with a carriage return just so that Sean doesn't get confused.
Well, I mean, I'm misunderstanding what you're saying. You just want me to distinguish it?
Yeah, I just don't want him to include it in section 121.
Yeah, good call. I'll make sure that's,
There's some way to make it look different.
yeah, I'm gonna do that right now.
Maybe highlight in purple or something.
Sorry, again, it just doesn't want to be responsive right now.
I understand.
Oh. I don't know why it's being misbehaving. I'm working on it.
It's me. Yeah, that's fine. Just yeah.
Okay,
Put that. Okay, now can we celebrate? Yay! Article 2. Okay, so 201. Again, we're keep with the articles. And then let's see. Make consistent with current. Oh, on 2 and 3, I just have a note that we want this to be consistent with current requirements. On B2 and 3, we have that.
2 and 3.
Well, yeah, okay, so we have here, yes, this reflects what I need, is just that we, there's requirements about what have to be in the articles, and I think we just want to keep those the same, right?
And it's just, I had it written, check with LC where in the statute is most appropriate, and it's this E, G, H, and J, or an I, sorry.
Right, and those are all, by the way, those are all 63047 1E, 1G, 1H, 1I.
Thanks, Cody. That is helpful.
Good, okay. Anything else on 201? Okay, 202. Yeah, lengthy discussions.
Yeah,
Lots of discussions. I remember all these like.
I have a question about B2, the street and mailing addresses of the company's principal office. And I was wondering whether we ought to iterate here again, that language of 63047-1H about, what that it has to have, a physical street address, including the number and name of the street, etc., so that foreign LLCs are treated the same, have that same transparency as local LLCs.
Yeah. So I think, and that's with respect to 2 and 3, right? So we just want to make sure that
Yeah.
consistent with the requirements there. So yeah, so just I would just add make where you are right now, Sandy. I would just do make 2 and 3 consistent with. Yeah, and I think that's good.
Great.
Okay. Anything else on, yeah, and then we struck that bottom. So anything else on 201? Okay, 202.
Wait, sorry, can you go back to D on 201?
We struck the last part of that, yeah.
Yes, okay, good, yep.
Yeah, that's what I had in my notes as well.
And do we have a comment about add the
Oh,
second
wait, Sandy, go
sentence
back
of
to
6?
that.
Oh.
Yeah, Sandy, go back to that.
Going back up top.
No,
Do we
well,
have a reference to 6307 for here in our stuff?
Where are you? No.
I had a note that we had decided to add as 201E, the second sentence of ORS 630741.
Was it 074 or 047?
047, I thought.
I wrote down for this part of it, I have other things that we were doing 047. For this part, I have 074, and the second sentence of 0741 is,
A person may not organize.
yeah, that can't be right. This wouldn't be the place to put that, would it?
No.
No, maybe it is 07.
So Sandy, we also need to delete in D and at.
And at, okay. I see it.
Need a period there, don't we?
Yeah, but let's delete this first.
Yeah.
As well.
I think that we actually had, I mean, I don't care where we put it in a sense, but I think we had, so 63074, this relevant sentence that you may not organize an LLC for any illegal purpose or with an intent to fraudulently conceal business activity. Again, we can just punt it to OLC on where to put it, but that's language that was added in 2017 and it's not in ROLCA. And we had decided we need to add that to our, keep that in our version of ROLCA. And I think we had tentatively decided it made sense to put it in section 201, but maybe we just add a comment here that that language needs to be added somewhere and OLC can determine where best to do so.
Yeah,
And
so
Cody,
the comment's sorry, go ahead.
Oh, I was just wondering if we are going to add that, do we need to give some consideration to the cannabis companies, which are acting illegally under federal law, but legally under Oregon law?
I don't think so.
Well,
I think we just leave it, the Oregon law as is. If people are making that argument that the LLC can't be organized because it's a marijuana one, they could be making that same argument today. Under current, I mean, I don't know that we want to get into marijuana policy in this.
But life has changed, right? With the legalization here in the state. So I think we should give some consideration to it, if we even want to include it.
Right. I mean, I was mostly, at least at this point, I was just reiterating that we had decided to add this language to our version of ROLCA, carry it over from our current Oregon law, which was just adopted 5 years ago.
Yeah, so Sandy, after D and where you have the cursor right now, do asterisk, legislative council to consider, second sentence of 63074.
0741.
Sub 1. Yeah. Does that look right?
Yeah, to consider where to add it. I mean, I think that would be a big deal for us to cut language the legislature just added 5 years ago.
Right. I mean, that's what I meant by consider, but where to add is fine. Good. Okay, moving on. What 202?
Also, I have this note that the group should further discussion about section D that goes along with the discussion of 401. It's just a note I had from a long time ago.
Of 201D.
Again, I took this a long time ago, but I put it as a note.
I don't have that note.
I'll get rid of it.
Yeah, I think we talked through that and agreed the deletion in D would stand.
Sounds good.
So 202, amendment or restatement of the articles. I think we were fine with A, B, and C. And then on D, there's no counterpart in the ORS apparently on this.
I had no change on I had us adopting 202 as is.
Yeah, I think I just have some notes based on the discussion, but yeah, and that's what I remember as well.
Me as well. No change.
Voting provisions.
And here's these notes. You can read the notes that I took again back when we had the initial discussion.
Yeah, and I think we did talk about the default voting provisions. So I think that's fine.
Okay.
Leave the note about client education.
Okay.
Okay, 203.
I'm just getting rid of this. 203.
I had a note to add section D.
Yep, here it is.
Yeah, okay, which is 63004 sub 7. So I don't have there's not a sub 7. I'm looking at 60.
And Michael, in your note, you said it's 63042B, which is.
Is that a 2 on my notes? Maybe that's a 2.
I'm just reading Michael's comment.
This makes more sense.
Sorry, I was
Now that
looking at ORS.
I was 2 and I'm like, there's no 7. So why did I write down 7?
Does it read how we want it to read?
Are we talking 2B of 004, 63004, 2B?
Well, section D comply with.
There is no 2B of 63004, although that I have the same note.
2B. Yeah, no, there is 2B.
Oh, there it is.
Yeah.
No,
that makes. I was looking at 1B.
it's 6B.
It's so confusing.
6.
6B. What?
No,
No, there's no 6.
63.004.
Yeah.
Really? Must have amended it. Oh, maybe I printed out my version before the HB 2998 got passed.
So so 2B is the part about declaring under penalty of perjury that it does not fraudulently conceal, obscure, all that stuff that's in the proposed D, which I think is what we had intended.
From my memory, that was what we were talking.
Yes.
Yeah. Again, where the legislature has articulated a policy, we're
Right.
just trying to stay consistent with that.
Yes.
Right, and I
that's-
thought we had wanted to add 2A as well.
2A. Article.
Like 2A, B, and C, like the capital B, and at least one member or manager must sign articles of amendment in each annual report. And the receiver, et cetera, must sign. I thought we had decided to add those things.
I don't have that in my notes. I'm not opposed to the idea, but.
It wasn't in my notes either, but again, also not opposed to it.
Yeah, and I do have a note about 63004-6A, which is what it must have been before they monkeyed with it. This is what happens when these projects go over like multiple legislative sessions. Okay, so in addition to the language that we have there from 2B, does anybody have any concerns about adding in 2A? Because I think that does make sense. And again, I would just offset this with asterisk, Sandy. So I would go asterisk, 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 Legislative Council to incorporate 63004-2A.
I think that's fine as a matter of policy. They should just check to make sure that we're not adding duplicitous language from someplace else. I don't think we are.
No, I don't think so either. And I think I think they monkey.
You mean duplicative?
Or duplicitous, either way.
You don't like duplicitous?
That's not, we certainly don't want LLC.
No,
I think it was just 2A, B, and C, which are the things that are not already captured by ROLCA.
Is this written correctly, Valerie? Do you want me to change it?
2A. I think that's right.
I think it's good.
Yeah.
And then we can see what they do and
Yeah.
we
if we
can
don't
fine
like
tune
it.
it later.
Agreed.
Okay. 204. I'm feeling good about this, people. Okay, 204. Any petition, yeah, state or federal court, that's I got like that. And then did we have a note under 2A or 204A3 attach about some attachment?
I didn't. I remember we talked for a very long time about the language of the state or federal court of competent jurisdiction.
Okay,
The only change I have on that is I think we had decided a state or federal court rather than the state or federal
Oh.
court.
Okay. I can fix that.
yeah, that just reads better. Okay. 205.
I will add the word A.
You like the word A?
It's a friendly word.
Yeah. Okay, 205.
Belder, I think the one issue, and I think Rose brought this up when we first discussed this section, is just that it imposes personal liability on members or managers if the filings with the state are not accurate, whether they don't reflect a member or manager, or what have you. And I think that's not something that's been adopted by other states. And if we're really trying to protect the carpet layers out there, they're the ones that are most likely to screw up the state filing. So
That's in 205 though. That's not in, that's part of our 205 discussion, right?
correct.
Yeah. So in 205, I've got a note about that under 2B.
Yep.
So someone had
I mean, even 2A, I mean, like it's just anywhere where we are imposing personal liability.
Hey.
I against it.
Valerie, someone had added the word reasonable here to A. Is that something we want to do?
My notes show that we had a healthy discussion about this section overall, and that we narrowly agreed to adopt this section and then narrowly agreed to add the word reasonable.
I think I have the same notes, Cody.
Yeah, I mean, I share your concern, Cliff, but I do remember that we went around this horse quite a lot. That's not even a metaphor, is it? I remember we talked about it quite a lot.
Yeah. Understood. If the group wants to pass and impose personal liability, I think that's unfortunate, but I'll go with the group.
Information to be inaccurate, the record is signed.
I actually do think this is an area that we should just, based off Cliff, and I remember this discussion, this is one we should just keep an eye on when it's going to be up for the legislature, because that's an issue that
Yeah,
some,
so we can flag it for them. I mean, I
Yeah.
think, so maybe when we go down to comments, because I do think that it was a close, yeah, see, we have the.
oh, I have the note of it. Yeah, right there.
I think depending on the people at that meeting, had it been it had a different composition, we may have had a different result.
Which is fair. I mean, I think it's a policy decision. So can we after 3 here, Sandy?
Yep.
Put in, well, okay, one more character. Just flag policy issue related to personal liability. And this is probably going to go through judiciary, so flag it for the Judiciary Committee.
Mm-hmm. And we now have an OLC member on both judiciaries again. So that's good news for us.
Yeah, so related, okay, flag policy issue related to personal liability and should be for Judiciary Committee.
For judiciary. Yeah, oh yeah, thank you.
There's too many relateds.
Yes, there. No T. Sorry.
Okay, you're doing better than I would when you're typing under pressure.
Not anymore. All right.
Okay, were there any other concerns or edits that can you go back up to the language for 205, please, Sandy? Yeah.
The only thing I had marked that we actually changed was the word reasonable.
Yeah, and
Despite-
that's what I've got too. Just making sure that everybody else's, that's consistent with everybody else's notes. Okay, 206. Oh, wow, we talked about this one a lot.
Oh, yes, we did.
Okay, so 206A, no change to 1, 2, 3.
I had us in 3. The words in the record must be legible and in English.
Must be. I don't
Cody,
know.
that's in 63, right?
Yes.
That's where I think where it came from. I think it maybe the new 004.
63004. Oh, my note, my references are all messed up because they changed things.
Yeah, so 63004 requires it be legibly written in the English language. So I think we had decided to make it be the words in the record must be legible and in English.
So on 3, yeah.
Must be legible. So in 3, must be legible and in English. Is that what you read?
Yes, you add the words legible and.
Red.
And then where is this additional A language coming from?
And this is part of the discussion. I put it in green intentionally because we definitely didn't decide on it, but it was, I was told.
That's from the new 63004 sub 3A, right?
Right. It was very new at the time, so we just decided to put it as a placeholder.
Yeah. I mean, I think we had decided that we're going to incorporate the requirements under 63004 here. So I think if you scroll down, yeah, keep scrolling.
2998, that's the.
Yeah, and I think that we just language from. I think we just need to make a note for Legislative Council that we want this section to be consistent with the requirements of new. Yeah, so I would do asterisk, 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 or whatever. Legislative Council to make consistent with requirements in 63004.
Yeah, 3. Yeah, and I don't see in here reference to 63004, but that was something I think we had decided we needed to comply with as well.
Yeah, and so I think if we just say 63004, that should be sufficient direction to Legislative Council.
Is that enough?
Yes.
Is that okay?
Yeah, that works for me. Does that work for everybody else?
Yeah, let them wordsmith it.
Yeah. Okay, 207.
Well, can you go back up? I wanted to make sure I saw the rest of it. Because we had deleted B, right, and replaced it with.
Yeah, we deleted B and
Okay.
replaced it with.
We're going to replace it with 63041B, but Legislative Council can add that in there.
Yeah, they can, as long as we've got it
I
deleted.
think the note is, I mean, we were trying to wordsmith it based off this recent change back when we first fixed this, but I think Valerie's statement is we'll probably cover it here. That we're just intending to make sure it's consistent with the language that's currently 64004.
Yeah. As far as requirements go. And then if like we were saying, if we don't like what Sean comes up with, we can always revisit this. Okay.
I have a question, and maybe this ended up getting resolved, but in E, oh, we have F there may require, yeah, so on E, it says the Secretary of State can provide forms, but their use is not required. And 63016 says the Secretary of State can require forms. I have I don't recall that the Secretary of State ended up saying one way or the other whether they were okay with this change.
So I was just trying to look at it so that we may require.
Well, I think the point is that we want to make sure that we allow you the discretion you currently have under 63016.
Right, and I think that's good because now we don't have, well, very many that are actually required, and it's actually nice because a lot of attorneys' offices, when they're preparing documentation. They like to do the free form and have
Yeah.
their own, so.
Yeah, so I think that, yeah, so I think E gets us there.
So am I getting rid of this F idea?
No, keep
Oh, no,
keep
keep E and F.
F.
Keep E and F, because I think that
Color should be in red.
It should be black.
It should be,
yeah, it should be black.
F
Oh, it
is part of Rolka.
it should
Yeah.
be, a good call.
And then the green is fine, I think. And then, yeah, so go ahead and,
Yeah, I'll make it black.
and then to the legislative council note,
Yep.
I would just add comma 63016.
Thinking above in the green, I think you have complaint versus compliant.
And
If you go up half page in green, if forms are provided, to be
that
complaint.
was, yeah, that's an error.
There we go. Okay, good.
Yep.
207. Yeah.
I don't know why these were in green. I need to make these red.
Yeah, but you can do that after, right? I don't think you
Yeah,
have to.
that's true. They signify the same.
Okay, yeah, so we got rid of the time. And then 63011 sub 1 is what we're trying to do here, right?
Mm-hmm. 0111.
Yes, and that's the language that you've incorporated there, so that makes sense.
Yeah.
Although it's 63011, I don't know what the 3 is.
I'll get rid of the 3. Just made a mistake.
Yeah. That looks good to me. That look good to everybody else? And we got rid of 2, which I have in my notes. And then 3 and 4 we kept.
Yeah, I guess this, I don't know where this 3 came from, but I had written it down twice, but I'll get rid of it.
That's okay. 208.
I have no notes on this.
208 and 209 are clear to go, I think.
Yeah, I think so too. I just have cross references to current statutes in them. So we're really on 210.
Yeah, Cody, same thing.
Okay. So yeah, or other law in A, that's what I've got. And then B, when Secretary of State files a record, shall record it as of the date we crossed out the time of its delivery or as soon as practical thereafter. Yeah, it's fine.
Is that the language you want? I know there was a long discussion about that.
Yeah, I have practical, not practicable, but I don't care.
Oh, I think practicable. That's what I have. I have what I have what Sandy wrote.
Practicable is
I
fine.
remember Gerda's voice in my head saying practicable.
Oh,
but-
practicable is, I'm fine with that. Does anybody else have an objection to practicable? Okay. And get rid of time, and then going down to C, we changed it to 10, which is correct. D, yes. The domestic or foreign limited liability company. Yeah, and that's pulling language over from 63021, I believe.
That's what it says in the note. Yeah.
Yeah. Yeah, and so that's fine. And that's all I've got for, and then I think we should have a comment about the electronic notice stuff. I have a note about House Bill 2998.
Right here.
Yep, that works for me.
You want me to put a cite to that House bill, just so they know what we're talking about?
Yeah, House Bill 2998.
That was, I think, 2019.
I think so. It's all running together.
I have a question. I have a note here And I don't, on my own note, show whether this was something that was adopted or whether it was just a concern. But in front of A, 210A, it would have said, except as provided in RS 56.037, which references confidential information. I don't know if that was just a quirk or whether anybody,
I don't
had a
have that
note
in
on
my
that.
notes. I know that we talked about 56037, but I don't think that we added that.
well,
Okay, 211. Yeah, we did make these changes. Okay, so on A, issue certificate of existence, right? Because we don't do good standing certificates. The liability company, certificate of registration. Do we do, Jamie, do we do certificates of registration for registered foreign limited liability companies?
We do basically a certificate of existence for anyone who asks for it, but we don't have a certificate of registration that we give to them when they file with us.
Okay, so so I think we can delete the or a certificate of registration part of, no, an A,
I see it.
yeah.
So just, so start at or.
Yep,
there's
and
the-
then delete down through the period. Need the period, but other than that,
Yeah,
I think that's.
Well, don't we still want to leave in the foreign?
Well, we could add in domestic or foreign, I mean, right?
are we, I can't remember, are we adding that this is something? I guess we deciding we're not gonna do this. I thought when we discussed it before, I thought we were adopting this.
Well,
Well,
we're not adopting a certificate of good standing. They currently issue certificates of existence, right, for both.
Right, but that's different from a certificate of registration. I thought that's, the certificate of registration is the equivalent of a certificate of existence for a foreign LLC.
Well, that's why I'm asking Jamie is if they do this.
We provide, if they ask, if they request one or yeah, request one, then it's a certificate of existence and it's just the wording that how we say that they're authorized to transact business in Oregon, but it's not considered a certificate of registration.
And you do that for foreign LLCs.
Mm-hmm.
So
But you still call it a certificate of existence, Jamie, you just change the wording for a foreign LLC.
Yeah, so basically it's just, you know, if it's a domestic, then we say that it's organized. If it's a foreign, then we say that it's authorized to transact business. But it's all under the same title.
Right, so are you okay with the language as edited in A, Jamie?
well, we can't have it be the way it is right now with that strike through, because right now there's no requirement to issue any kind of a certificate for a foreign LLC.
I don't think we're differentiating between foreign or domestic in limited liability company in that language.
Yeah, it's an
No,
on
we are.
request.
Under ROLCA, limited liability company is only an Oregon limited liability
So
company.
we can add in, so we could add in then to address that for a foreign or domestic or foreign limited liability company.
Yeah, I guess just, you know, I would then change the strike through to just delete the words a certificate of registration for a,
Limited liability company or a registered foreign limited liability company.
yeah, have it read for a limited liability company or a
Okay.
registered foreign
Yeah,
limited
so-
liability company.
Yeah,
Or
so.
so I'm basically
unstrike
just,
through- Sandy,
I-
unstrike through foreign limited liability company at the bottom.
okay. I can do that. Oh, if it doesn't pop up on me, hold on. Sorry. Come on.
Everybody okay with that? Okay. And then B,
Sorry, we're still missing the words or a.
Yeah. Okay. Oh, like it's,
We still need the word registered though, don't we? Or
no. 'cause
Yeah, I
they're-
think you do.
Well, they're not registered, right? I mean.
Well,
do we
but
call them
you're not
registered
going to give a
vehicles?
certificate of existence to something that's not registered, and you can see the term is used down in B1 as well.
Okay.
Yeah, I mean,
I think
in my own view, I think registered is the equivalent of authorized to do business. That's how you get authorized to do business, is you register with the secretary. And the registered is used, you know, for example, in 211.3, and I think, you know, throughout the ROLCA, you know, it's in 211.4B, for example, this concept of companies being registered.
Yeah.
Or I think if we're going to get rid of the whole concept of a foreign LLC being registered, that's, you know, or
Okay, so
you know,
here's
as
Sandy.
compared to being authorized to do business,
Sandy,
that's just, we need to be thoughtful about how that affects the rest of what we're doing with ROLCA.
Sandy, type or a registered where you have the cursor now.
Yep.
Okay. B. A certificate under subsection A, when issued, which I have in mind, means that, yep, I've got that. And then I have.
That grammar is broken, isn't it?
Where?
Under subsection A, when issued,
It means that
the
the
limited
LLC's
liability-
name used in the state.
Are we missing words?
Well, it used to say must state, which I think gets you the right.
Oh, okay, so let's go ahead and strike the. Yeah, I think you're right, James.
What am I striking, Valerie?
You're getting rid of the change, so we're going back to must state.
Okay.
Is Jamie, okay with that? You're adding a textual requirement in the certificate of existence.
I was just I was going back and looking at what we have now
Mhm.
and how we say it. So we say certificate of existence or authorization. Because I was still kind of going back on that part of it, just because I wanted to see how we address that.
Oh, well, yeah, maybe under A, rather, all we need to do is replace the word instead of a certificate of registration, we just call it a certificate of authorization.
Mm-hmm.
And then would that match your current practice?
Yes.
Because it is kind of weird for an Oregon Secretary of State to issue a certificate of existence for a foreign LLC.
Yeah.
Right.
Okay, so.
Okay.
Sorry, Sandy. So it would read or a, and then on A, next line.
Yeah.
Or a certificate of authorization, Jamie?
Well, you just kill all of the strike throughs
Well, no,
and then
but
you
we
just
added
replace the
in-
word registration with
no,
authorization.
We've added in or a, so it's going to be more efficient if we just add in
Sure.
a certificate of authorization for a.
Okay. So
It's fewer changes.
Can I move that we change the font?
No,
that
absolutely not.
Where's the serif?
I will make that all consistent when we turn it over. That is a later job.
Sorry,
Okay.
Sandy.
James is just trying to cause trouble. Okay,
Does this look good?
yeah, but you have to make that certificate of authorization or make authorization red.
Yeah. Well, yeah. That's right. Come on. Red. There it is.
All right.
And to go to Michael's question that he asked Jamie was, my recollection from the discussion was that the certificate issued by the Secretary of State doesn't actually state the things that
Right.
211B requires be stated, but which is why we had changed it to mean to say when issued means that.
Yeah, the Oregon counterpart there is 63027 sub 2, which the leadoff phrase says a certificate of existence or authorization when issued means that : it seems like it would make sense to keep something, that language or something close to it.
I mean, I'm fine either way. It's whatever the Secretary of State wants, as far as I'm concerned on this.
So can we just have, well, can we just insert a reference here to that B needs to just be consistent with what the Secretary of State requires? And then Sean can fiddle with the language. Jamie, would you be okay with that?
I'm okay with that because it's a little bit confusing the way that it's showing now.
Yeah,
So-
so I think that what, I think, yeah, so Sandy, just put here LC to make consistent with current practice.
And that, I would flag 63.027 as well. They want to be looking at that statute in the context of this subsection.
Right.
Look,
63.
63.027, is that right?
Those paren
Correct.
adds an asterisk, yeah. And then I would just highlight the rest of that.
Of this, just highlight this situation.
Yeah, so basically B1 and 2.
That makes sense. If it actually will do what I'm asking it to do.
Yeah.
We're asking the computer to work hard right now. It's not enjoying it.
It doesn't like highlighting for you, does it?
Doesn't. I don't know what's going on with that.
Do you have to go in and accept the changes and then highlight?
Yeah, it's the two-step thing.
This version of Word is terrible.
It's clunky. It's nice that it's shareable, but it's really clunky. I mean, if I had a super new fast computer, I think it'd be fine. It's just taking a lot of resources right now.
Okay.
Oh, for goodness sakes. Oh, what?
New motion. Can I move that OLC buys Sandy a new laptop?
Just thinking that.
I didn't want to talk about the OLC budget, but you got to talk to the legislature about that. The Oregon Judicial Division, you got to talk to the judges about that,
Well, that's a whole nother discussion.
which I recommend. It's okay.
Yeah,
Now it's in green, so that's fine. At least it worked.
yeah, that's fine. That works. Okay, so moving on. So under 4,
4, yeah.
yeah, I had, did we delete the whole thing or I just?
No,
I
we
just
only
had-
deleted the words taxes, interest, and penalties.
That's what I had as well.
Okay. I can fix that. We just deleted taxes, interest, and penalties, correct?
All that we deleted.
Come on. Sorry, after 3 hours, it is just crawling at this point.
Yeah, I understand. We are so close to being done with this section though.
I'm
and
working on it.
12 we just struck, so I want to get through to 12.
Wait, actually, I'm going to do it different. I'm going to do it easily. It's literally, all we're doing is getting rid of the words taxes, interest, and penalties,
Yes.
right? All right. So what I need to do is go up here.
Oh, yeah.
And then I'll change the color back to black once I do this.
Yeah, good.
Then I'll make the rest black. And OW.
That's don't fuss with it. We're so close.
I know.
Okay, so I had us deleting 6.
Yeah.
I had that gone.
Okay. And then C, yeah, and subsection B. stated in subsection B. Okay, any other changes to 211?
Well, good news. It looks like we'd actually already talked about this note for 63027. If you look at the bottom here.
Yeah. Oh, yeah, good. Yeah, so 63 anything else on 63-211? No? Okay, 63-212, I just have us deleting it and replacing it with 63-787.
That's what I have.
That's what I have.
Yeah.
Anything else on Article 2?
Yeah.
On 212, I just wanted to, as it'll be restated, is this requiring disclosure of all members, all managers? I can't remember where we,
No, I think it's just preserving current Oregon law, isn't it?
Yep.
yeah, but so what does that require? Does it require all members and all managers? Or excuse me, all managers or all members?
I don't think so. Isn't it just one of either?
Well,
Yes,
that's the way roll call is, but I recall there being a lot of discussion on this point. As to how far you needed to, or how many names you would need to include.
Oregon only requires one member be.
Yeah, and that's in
Okay.
63-787
Right.
1D.
Yeah, it's right here. It's on.
Yeah. Perfect. I'm good.
All right, anything else in Article 2?
The only other thing I have is 63.024 evidentiary effective copy of filed document was something that we thought should either be moved to Article 2, like as a new section, or OLC should move it to ORS 56.110.
Yeah, okay, so Legislative Council to consider adding 63.024 to Article 2.
Yeah, or move it to ORS 56.110.
I'm sorry, you said 64? I apologize.
56.110.
Thank you.
Yeah, no problem.
Just used to hearing 63, so if I hear a different section, that brings those
Okay.
weird.
Yeah.
Great, fantastic work, people. Yay!
That was a very productive meeting. Good job, everyone.
Yeah, so next time, hopefully we can get through Articles 3 and part the way through 4. I think 4 is going to take us some time. Because I know that particularly like 410, there was a lot of discussion on, but great
Oh, yeah.
job. Thank